Mr. Diaz?
If it please the Court, good morning. Justices, John Lee Diaz on behalf of the petitioners.
Thank you.
The facts of this case are that the underlying case involves Attorney Richard Murphy, who apparently had taken the representation of the Harrisons for application of a special permit, which had been denied. But in particular, was the disbarment that took place of Attorney Murphy, which involved the actions of the Harrisons as well as other individuals he represented, and in particular during the time that he worked for the defendant's Roncone law office. Apparently, it's alleged that while he worked for the Roncones, he forged some court orders and made some misrepresentations, and in particular that when he was hired by the Roncones did not fail to supervise him in the proper fashion while he worked for them, and they basically gave just a cursory review of his work. But going back, what happened was Attorney Murphy had worked for two prior attorneys, Angelini and Holmes, and then worked for Attorney Roncone. And during this period of time, Attorney Murphy made certain misrepresentations, which subsequently led to the special permit that the Harrisons had hired him for to be disallowed. But even though the special permit was disallowed, he continues misrepresentations while working with these attorneys, which subsequently led the Harrisons to hire an attorney to sue Attorney Murphy, Attorney Angelini, Attorney Roncone.
This may be all well and good, and you can use your time any way you want, but where is the error in the single justice not granting relief?
Thank you, Your Honor.
Because can't you raise all these issues on an appeal from the final judgment?
Well, that's the crux of the matter, Your Honor, is that there's two positions that we've taken. One is that there was never a final judgment adjudicated in this matter.
Well, then you can go get one.
And you go back to the court and get one, and you take an appeal, and you can raise all these issues.
Well, what happened is Your Honor, is that just going back a little bit, and then I'll answer that question, hopefully, is that Attorney Roncone's deposition was taken in the year 2000, and he indicated that Attorney Murphy had stopped working for him in 1996. And based on that, in the year 2001, he had made a motion to get dismissed from the case. And because there was no evidence to show that Roncone...
Oh, I understand that, but so the motion to dismiss is allowed, right?
Well, the motion to dismiss was allowed. And then what happened was when it came up...
Right, but there was no separate and final judgment on that, so until everything is over, that's not part yet of any final judgment. Yes. Just all you need, it seems to me, is to get that, now that everything else in the case has been resolved, get that reduced to a final judgment and appeal. And
what happened, Your Honor, was apparently when this came before the single justice, what came out was that the motion to vacate the default, and this is not about a case, the motion to vacate the default, the motion to vacate the default was denied, and that's not what was wanted. What was wanted was to have the motion to vacate the dismissal of Roncone allowed so that Roncone could be brought back into the case. And the justice indicated that it was Rule 60 when it should have been Rule 54 because this is a multiple party case involving more than just the Harrisons and Roncone and Murphy, but involved Angelini making cross-claims and counterclaims, so it's a multiple party case. And that's what the confusion was in this case, Your Honor, was that the motion to vacate the dismissal was denied based on the fact that through some analogy a final judgment took place and that Attorney Berger had 1 year to vacate the dismissal. It wasn't done within the year when Attorney Berger believed that because of the multiple party case no final judgment had been allowed, and therefore he had until the case finally resolved with Attorney Murphy.
This isn't about the time to bring a motion. This is about getting a final judgment from which an appeal can be taken of all of these issues. And I understand it's been a procedurally complicated matter, but at this juncture it certainly ought to be possible to get what you say is the erroneous dismissal reduced to part of a final judgment from which you can appeal, and all the issues about whether that dismissal should have entered, whether it should have been vacated, et cetera, are then part of your appeal.
And we believe that the position of the defendants in this case is going to be that that time period, by analogy, the final judgment had taken place, and that time period elapsed in 1 year, and we can no longer go back and wait.
But you don't know that they'll take that position, and if they take that position,
That's a different story.
you can take an appeal from, and if the judge, if they, A, if you don't know if they'll take that position, B, if they do take the position, you don't know which way the judge will rule, and C, assuming they take the position and the judge rules against you, you can take an appeal from that order.
Okay, thank you.
Thank you, Mr. Diaz. Mr. Hamilton? And thank you for accommodating the court, Mr. Hamilton.
Madam Chief Justice, members of the court, may it please the court, my name is Terrence Hamilton, and I represent the respondents' appellees, John Roncone, and his law firm, John Roncone, Jr., P.C. I feel a little bit, based on the comments of the court this morning, that perhaps I'm preaching to the choir.
In which case, I suggest you use your time judiciously, Mr. Hamilton.
I certainly
the
will.
suggestion is, as you've heard, is that this is not a 211-3 matter, and that the single justice properly said it was not a 211-3 matter.
Yes.
Because there is another way to get at this.
That is absolutely correct. The issue before you under 211 Section 3 is whether this court can use its extraordinary power under these particular circumstances. And this court has said time and time again that if ordinary appellate review is available, the court may not exercise its power under Section 211, under Chapter 211, Section 3. And therefore, the single justice, in ruling as he did not abuse his discretion and did not commit a clear error of law. There is no question here, but the dismissal which the petitioners are seeking vacation of was not a final order. That was clearly said in all the briefs that were submitted below. Once a final order and a final judgment is entered in accordance with Rule 54B, then this entire matter will be ripe for review. So that unless the justices have any further questions on that issue, I have nothing further to add on that point. However, in addition, we've also brought a motion for sanctions based on the allegations and the statements that were made in the briefs going as far back as the Superior Court. In the reply brief in which the petitioners submitted, they have accused both the defendants and their counsel of obstruction, trickery, misrepresentation.
You mean you're asking for sanctions in connection with some stuff that occurred in the Superior Court on a 211-3 petition? Is that what you're asking? Or have you separately appealed from something? Or where does the sanctions come from?
The sanctions come from the briefs that were submitted on behalf of the petitioners in this court. And the sanctions are being requested under Chapter 210, Chapter 211, rather, Section 10, in Rules 25 and 26 of the Massachusetts Rules of Appellate Procedure. This court, in Avery v. Steele, made it quite clear, I believe, that counsel should not engage in scurrilous, unfounded statements. There is not a scintilla of evidence that either John Roncone or yours truly participated in any obstruction. The briefs are all before the court. It's all quite clear what was said. It was all quite clear what the justices of the Superior Court decided and the basis upon which they decided it. I believe I have a pretty thick skin as far as these things go, but when I hear it over and over again, it's clear to me, and I think to this court, as they said in Avery v. Steele, that counsel should not engage in this type of conduct. Thank you.
Thank you, Mr. Hamilton. Mr. Berger?
May it please the Court, the defendants are getting just what they want here. Misrepresentation. This gentleman cited a case saying that relief must be sought within 1 year of the order. The decision said that must be sought within 1 year of the entry of judgment. I am not a fool. The reason we are here is because I have old, dying clients. They were conned in the trial court with a total misrepresentation, an actionable misrepresentation. And here's the way it went. Nobody wants to listen, but I want to put it on the record. In spite of Rule 54B, Rule 60, Rule 77, Rule 60, 54-2 of Zobel Mass Practice, citing 17 cases to the contrary, Holner v. Wisnowski, Keenan v. Maybrook, ISK v. Commonwealth, they got what they wanted, which was...
Mr. Berger, we've got a very good sound system.
I understand
It's
that. I am sorry. I am very angry that someone who concedes that
Berger.
Rule 60 doesn't apply is making these accusations about me after 30 years of practicing law. And let me say this. You saw me recently on the case involving fresh complaint. If I miscited the law of fresh complaint the way the insurance lawyers did here, there would be rapists that would be walking around the streets, and you know it. And I could tell them the story.
Mr. Berger, could you please confine your comments to the arguments that are relevant to this case?
Yes, I'm responding to his motion. In Commonwealth v. Clerk Magistrate, 439 Mass. 352, 354, 355, the rule was modified, not what my brother had said. It says, quote, orders entered by a single justice under 211, Section 3, are not to be disturbed absent abuse of discretion or clear error of law. The judge entered a written order. It was a clear error of law. We need to get to the trial judge because there are a number of defendants who are sitting on the fence, and they're waiting to see what happens. Okay, here are the clear errors of law that nobody wants to hear about. Number one, the decision of the SJC, a written decision of the Supreme Judicial Court, says, petitioning from the denial of their motion to vacate a default judgment. The plaintiffs won a default judgment of $1.6 million. Two, the judge said, this involves a final judgment that has not entered in that action as to the default judgment in question. There is no default judgment in question. Why do you think we were applying for emergency relief? Mrs. Harrison is dying of cancer. Mr. Harrison has an active brain tumor. Do you think I am not aware of the limited jurisdiction of 211.3? My God, I've been doing this for 30 years. I have 26 written decisions, and I am in the ALI. And this gentleman miscited the law, and I could miscite the law on a number of things, and it was a game, and the game is very clear. If you tell the court that you're under Rule 60, then all rules are off. Discovery hadn't finished in this case. Discovery was going on. We subpoena in a record. The record indicates this, and this is what we're dealing with. The record indicates that on the day that Mr. Murphy sent a forged order of Judge Barton to those people, it was the day that they received a check for $2,500. Discovery was open.
Mr. Berger, may I ask you this? There was a motion to dismiss granted
Correct.
Against Mr. Hamilton's clients, correct?
Yes.
And has final judgment entered with respect to those defendants?
That it has not, Your Honor. I would love to enter it as those defendants. The difficulty is that Gregory Angelini, another cross-claim, has a cross-claim both against Holmes and Poitras, Holmes and Murphy. I would love to do what you asked me to do, but I can't. It's not that simple. You have set up the rules under 54B because it says the elementary principle that in any action, the court short of final judgment or decree remains within the control of the court and is open to revision until final decree. You know, it's been your line of decisions that have said that it is not a fait accompli to have allowed a motion for entry of final judgment. That was his excuse.
But have you moved for the entry of a separate and final judgment?
No, I can't,
Why can't you do that? I'm just curious. Why can't you?
Because it would not be permitted under Rule 54B. It would not be permitted under your line of cases of entry of final judgment. There is no possibility because that's not the doctrine. The doctrine is that there are ways that you can make interlocutory rulings. I mean, let's be realistic. I can come in. Wait, may I just finish? I know I'm.
In what particular respect do you think that you are precluded from filing a motion that says I want separate and final judgment to enter with respect to these defendants?
Oh, may I explain that? I'm sorry. Under the doctrine of ISK of New England versus Boston, 14 Mass App Court 327, 330. It says that we cannot have piecemeal litigation. Therefore, the court can deny it. Now, I was not in a position to file that, as likely as I was to file a petition for interlocutory review. Why? Because it's a simple question. I got a default judgment for me, not against me. I went to the appeals court, and they only said the same stuff, which is we don't care for interlocutory stuff that other defendants. It doesn't matter. The other defendants have a bunch of claims among themselves. This is not a Mickey Mouse case. This is a $1.6 million involving forgeries and so forth. And I just ask you this question. I have been before you on motions to suppress that involve sentences of less than 6 months, and you've given the Commonwealth the right to interlocutory appeal. I have dying clients with a brain tumor and cancer, and I look for interlocutory review, and what I get from this man is sanctions. Now, may I address the sanctions thing?
I'm afraid, Mr. Berger, your time is up.
All right. May I say one thing since it's on my own dime and on my skin? I filed a motion to strike the reply brief because I felt that it seemed like a good idea at the time to go into these things, and at the time it seemed to me to be appropriate to point out to the Supreme Judicial Court that there was extraordinary misconduct, which is verified on the record. This involves forgeries, point-blank misrepresentation, 3 misrepresentations in a 3-page brief to the trial judge. And do you know, when we were dealing with the King case, there were 5,000 pages without one misrepresentation because I checked them all.
Thank you, Mr. Berger.
All rise.